Who's off the Teams meeting?
Yes. Mr. Coppell, I'm very sorry. My laptop will be brought in a moment.
Do you want me to wait, my lord?
No, not at all, no.
My lady, my lords, I'm going to concentrate. We'll start with ground one. First of all, setting out the Commissioner's position in relation to it, and then answering what my learned friend this morning described as his 8 points. Then I'll go to ground two and my additional reasons for upholding the decision below. So, starting with ground one, the court will recollect that in the judgment below, the judge observed at the start of his judgment, paragraph 3, that if the claim before him succeeded, it was going to have huge ramifications as to the workload of the Information Commissioner, which he said and recognised rightly would be vastly increased. And he also observed in paragraph 3 that the resources of the Information Commissioner were already stretched to the limit in dealing with the current workload. My learned friend's position, the appellant's position, is that this is irrelevant. And according to the appellant, and I'm quoting here from paragraph 52 of his skeleton, whatever the true figures, he says, the resources available to the Commissioner are irrelevant to the legal question of whether he, the Commissioner, is required to determine the complaints made to him. Now, the complaints being spoken to are not informal complaints. It has a technical meaning. They are complaints made pursuant to, in the case of general processing, Article 77, and in relation to, that's Article 77 of the UK GDPR, and in relation to processing by law enforcement bodies or the intelligence services under Section 165 of the DPA. The court will be aware that the regime is split into 3 streams. So you've got general processing covered by the GDPR, you've got law enforcement processing by law enforcement bodies, which is part 3 of the DPA, and you've got intelligence services, which is part 4 of the DPA. And you see this conjoining of them in the administrative provisions that we've been looking at. So sometimes it refers to part 3, part 4, sometimes GDPR. But all of these are complaints that there has been, in the phrase used, an infringement of the data protection regime, either by the controller or by a processor. Now, whether or not there has been an infringement of the data processing regime is not always, or indeed generally, a straightforward question of straightforward legislation. And the court will have seen that the GDPR itself is over 100 pages long. The King's Printer's version of the DPA is over 350 pages long. At the heart of the appellant's appeal is his contention that with every complaint, every such complaint that the Commissioner receives, the Commissioner must keep on investigating for however long it takes until he can determine whether there has been an infringement of that regime. And, my learned friend says in his skeleton, the Commissioner has to do so regardless of how many complaints he receives each year and regardless of the cost of making such a determination for each and every one of them. My lady and my lords, that is unreal. It is as unreal as it is unsupported by the legislation. The reason that the appellant submits that the cost to the Commissioner is utterly irrelevant is because the figures make difficult the central proposition in this appeal. In order that the Commissioner is able to determine whether or not there has been an infringement of the data protection regime, the Commissioner must investigate the facts with sufficient thoroughness that he can safely determine the applicability of each of the provisions in the regime that may impinge upon the complaint. The Commissioner has to give the controller a fair opportunity to comment on what he has found and what it is open for him to do. Now, in the appellant's case, one of the issues was the applicability of an exemption to Article 15 of the GDPR, right? GDPR, that's the subject access right. Exemptions from Article 15 are contained in Schedules 1, 2, 3 and 4 of the Data Protection Act. And those 4 schedules alone occupy 50 pages. Schedule 2, which was in play here, runs for 18 pages and itself has 28 main headings of exemption. One only has to glance at that to see that its application is not a simple matter, and there is no reason to assume or to imagine that it would be any simpler for any other of the tens of thousands of complaints that the Commissioner receives every year. To make good this point, it needs to be understood how many data protection complaints, that's formal complaints under the legislation, the Commissioner receives. And these are set out in his annual report published. And in summary, for the last financial year, the Commissioner received 33,743 complaints. He issued 39,724 outcome decisions, and they were of 2 sorts. The first, approximately 25,800, were recorded as no further action, and in some of these, the Information Commissioner gave good practice advice to the controller. So no further action, but here's some advice. And that included complaints, for example, where a subject access request hadn't been answered in time, but had been resolved by the time that the Commissioner came to deal with the complaint. Of the remaining outcome decisions, that's approximately 13,900, there were a number of different ways in which they were responded. In the majority, the Commissioner concluded, although the evidence fell short of establishing an infringement, nonetheless, the Commissioner thought that the controller needed to do more to resolve the issue, and so invited the controller to reconsider its position. In another group, either the controller admitted the infringement or the Commissioner concluded that there had been an infringement, but the consequences were relatively minor and below the Commissioner's threshold for taking regulatory action. So what would happen, or what does happen in these cases, is that the Commissioner provides advice to the controller and asks it to put things right so far as the data subject is concerned. There are other cases where the Commissioner couldn't do anything under the legislation and the complainant would be so advised. There were a few, approximately 10 cases, where the investigation team was instructed to conduct a formal investigation, and in just 2 cases was formal regulatory action taken. Now, my lady and my lords, like all public authorities, the Information Commissioner has a budget with which to carry out its various functions, not just under the data protection legislation, but under other legislation that he's called upon to implement. Freedom of Information Act, Environmental Information Regulation, so on and so forth.
Could I just check with you, these figures, are they the same sort of figures that the judge heard from Mr.
They are. I think he might have had the earlier years, but these are the latest figures as they've been given to me, but plus or minus.
Mr. Coppell.
Sorry, the judge below was only given headline figures for numbers of complaints. I've no idea where Mr. Coppell is reading from. I haven't seen the document or what.
Right. Well, I asked because Mr. Jason Coppell was asking you for, in a polite way, for how many cases you had actually investigated to the death, and you've now given some information. But I don't raise any objection to the fact, but this information was not, as it were, evidence that was before the court. No. It might have been publicly available. Is that available in the annual report or simply available?
I understand it is available in the annual report, and I can make that available to my learned friend and to the court. But my learned friend's point is it doesn't matter what the figures are. I could be giving the court any figures.
But I mean, I understand why you're making this general point, and of course the very precise figures don't matter. It's the overall picture which you're entitled to situate the case within the reality of day-to-day work. But I don't take it that you're arguing with what the judge said, namely that if that's what the law is, then practice has to change. I presume you're giving us these figures in order to say it's very unlikely that it was intended to involve such a huge change in practice, because this is the system that had been running before and continues to run today. But put me right. I mean, if it was said in the GDPR, you will investigate every case and decide whether there has or has not been an infringement. Well, if that's the law, that's the law.
If that's what it said, but it didn't. That's our point. And the question is whether one needs to read that in, and that's why we've been considering the various provisions in the GDPR and the Data Protection Act, whether we are to read in that the requirement to investigate to the extent appropriate means you must investigate to such point that you can reach determination in each and every case that there is a complaint.
Yes, and the complaints function of your organisation is one part of its efforts to maintain the GDPR in effective operation. Your argument appears to be that it's not dealing with complaints as if it was simply a single complaints department and a department store.
No, and of course there are other functions apart from dealing with complaints of the Information Commissioner. Now, it's important to understand where the funding for this comes from, because obviously the Commissioner has a budget with which to carry out its various functions. As I've said.
I'm rather querying, particularly if you're giving information that wasn't available to the judge or to hasn't been brought into the proceedings, why we need to know this. I mean, you've set out your stall by explaining that, in effect, although my words not yours, that you take a holistic approach to upholding the GDPR, of which handling complaints is but one aspect. And I'm not sure where we're going with talking about budgets.
I think as I understand the suggestion made this morning by my learned friend was that, well, if that's what the GDPR requires and the Act requires, then there needs to be an appropriation of money for it to carry out those functions. The enforcement of data protection isn't principally, or indeed at all, so far as I understand, that comes from an appropriation. The Act itself, that's section 137 of the Act, requires it to be defrayed from charges made of controllers. So every year, a data controller, depending on its size, must pay to the Information Commissioner an annual fee up to £2,900. So if my learned friend is right, and this does result in a significant increase in the amount that has to be expended to investigate everything to the nth degree in order to be able to reach the determination, that is something that is going to be defrayed by additional charges on controllers. That's the only point that I made there. It doesn't come from governmental or departmental, I should say.
But this all seems to go beyond the parameters of the judge's decision-making. I can see that if this was a purely domestic statute, that point that you've just made might be a pointer in favour of a more a narrower interpretation of the Commissioner's duties, because it would make clear that there's some kind of limit on the amount of money that can be obtained through the mechanism, through the statutory mechanism. One of the features here, though, is that this was not a free choice in the relevant respects for the UK legislature at the time it was originally came in. Is there some point to be made about the fact that by the time it became the UK GDPR, there was a proper free legislative choice?
To go back a step, although it was a regulation, so it had direct effect, the regulation itself gave national legislatures a latitude in how they implemented it. And that's most obvious in Article 23, which resulted in the 50 pages of exemptions that we see in the DPA. But there were others as well. So yes, it was a regulation, but national legislatures were given a latitude. The point really goes to what is the more likely interpretation that is correct of these provisions, where it has not said in any of the articles referred to by my learned friend or in the DPA, it has not said you must in every case reach a determination. That is a read-in that my learned friend's ground one requires. And what I say is that read-in that he would like written into this provision is particularly unlikely because of where it leads us to in terms of practical consequences. That is not how we read a domestic legislation. So at the heart of this first ground really is whether with every complaint that's made to the Commissioner under Article 77 of the GDPR, the Commissioner is required to investigate that complaint to such a point that he can determine it, or more precisely, whether the Commissioner must investigate it to such a point that he can, and he does, determine that the controller has not infringed the GDPR, or has infringed the GDPR. And as I said, although this appeal is concerned with general processing, the point carries across to processing under Parts 3 and 4 of the DPA. And the first ground then, I mean, candidly accepted by my learned friend, is not concerned with whether the Commissioner was right or wrong to decide that the appellant's case, that in the appellant's case, he wouldn't determine whether Wise had infringed the data protection regime. It asserts, the first ground asserts, the Commissioner had no choice in the matter. He had to make that determination. And what holds true for the appellant here would hold true also for the 33,000 plus other complaints made each year to the Commissioner. With each of them, no matter how small, no matter how trifling, no matter how prosaic or inconsequential, according to the appellant, the Commissioner would have to determine whether the data protection regime had been infringed, and he would have to do so no matter what call was made on his resources, and indeed no matter that the controller had rectified matters. And the Commissioner would have to do so no matter that he was of the view that further investigation would not be a sensible use of his limited resources. According to the appellant, the concept of diminishing returns has no role to play here. And that, as I say, is how the first ground is couched. Now, in the skeleton argument, a series of complaints was made, 5 complaints really, made about the judge's judgment below, running from paragraphs 32 down to 53 of my learned friend's skeleton. But the beginning and the end of all these complaints are the words of the GDPR and the DPA, and we start with Article 57, which is the same place my learned friend started this morning. And in relation to the processing of personal data covered by the GDPR, it is the main list of the Commissioner's tasks. If we turn to that, in the bundle, it's at page, starts at page 102. And so far as complaints are concerned, it's paragraph F that sets out what the Commissioner must do. So far as relevant to complaints such as Mr. Delo's, he must, first of all, handle complaints lodged by a data subject. Secondly, the Commissioner must investigate, to the extent appropriate, the subject matter of the complaint. And then thirdly, the Commissioner must inform the complainant of both the progress and of the outcome of the investigation, and he's got to do so within a reasonable time. 3 elements in paragraph F. And there are 3 observations to be made at this point. And the first observation is that the scope of the duty to investigate the subject matter of the complaint is limited. It is limited to, quote, the extent appropriate. And implicit in that is that although further investigation by the Commissioner might be possible, if it is not appropriate, the Commissioner need not take it. The second observation is that the phrase, to the extent appropriate, is left at large as to what it is to be appropriate to. And there is nothing in Article 57, or for that matter the UK GDPR, to suggest that cost constraints are not appropriate matters to be taken into account when considering the limits of any investigation, or that the ramifications of the particular complaint are irrelevant, or that the number of people directly affected are irrelevant. They are all matters that can inform what is, quote, to the extent appropriate. And the third observation to make is that paragraph F imposes no duty on the Commissioner to make a determination whether there has been an infringement of the data protection regime. The duty to investigate, the duty in Article 57(1)(f) is an antecedent one. It's a duty to investigate, and then only to the extent appropriate. The extent appropriate may stop short of being enough with which to determine whether or not the GDPR has been infringed. The next provision to take into account is Article 58, which starts at page 104, which sets out in 58(1) the investigative power of the Commissioner. Now, we've just seen that in 57(1)(f) there's a duty imposed on the Commissioner to investigate, to the extent appropriate, the subject matter of the complaint. And 58(1) sets out what the Commissioner's powers are, and it runs down from A to F. So A says the Commissioner can require the controller and the processor and any of their representatives to provide information necessary for the performance of his task. Now, under section 115, which is at page 153 in the bundle, it's 115 subsection 5. The only way in which the Commissioner may exercise this power is by giving an information notice. And information notices and the manner and circumstances in which they're given is itself governed by sections 142 to 143. It's enough to observe that it's a highly regulated process, both as to the circumstances and manner in which such a notice may be issued, and having been issued, it's subject to a merit appeal to the first-tier tribunal. Second power in 58(1)(b) is to carry out investigations in the form of audits. And these are to be exercised, and we see this in section 115 subsection 6, only through an assessment notice. You may remember in my learned friend's submissions this morning, referring to the Data Protection Act of 1998, he took you to the provision referring to assessment notices. Now, the difference, the prime difference between the 98 regime and the current regime is that there, under the old regime, the data subject would ask the commissioner to go and make an assessment notice, to go and issue an information notice. It's not how it works under the current regime. Under the current regime, which is, if you like, more friendly towards the data subject and assumes that the data subject may not be au fait with all of these provisions, you make a complaint to the commissioner, and then the commissioner considers it and the various powers that the commissioner has under 51(8)(1), and those powers are constrained through section 115 of the Data Protection Act. So that's paragraph B. Paragraph C can carry out a review on certifications. Paragraph D can notify the controller of an alleged infringement. Paragraph E, he has power to obtain from the controller and the processor access to all personal data and information necessary to perform his task. And this can only be done using the Schedule 15 power, and that's because of section 1157. And we don't have, I don't think, in the bundle Schedule 15, but it's not the ordinary warrant provision to enter and go into premises. It's a power on the commissioner to look at machines that are present on the premises, to test them.
I'm just wondering, do we need this level of detail? I mean, one sees we've looked at Article 57, which is intriguingly entitled tasks, and these are powers. So we have the look of it. Do we need the detail of these individual powers?
I think we do, my lord, because what's being said here is that in all of these cases where a complaint is made, the commissioner needs to do everything that is necessary to work out whether there has been an infringement. If you carry that through, to one side this particular case, if you carry that through, that may include requiring the commissioner to get a warrant under Schedule 15, to go into the premises, to test the equipment to see whether there has been an infringement of the data protection regime, to ask people who are present on the premises questions, which is what can be done under Schedule 15. This is how extensive it is, or can be, I should say.
Well, it would be if that was caught to the extent appropriate.
Quite.
Right. So I think we've grasped the point that many cases are complicated, that the entire regime is complicated, that if one had to investigate everything, then it might quite often be appropriate to have to use very extensive and complex powers of the sort you're showing us. Is that really what you're conveying?
My point is that in order to reach a determination whether there's been an infringement in some cases, if this were universally required, it will require the commissioner to go in to inspect the premises. This is what is being called on by my learned friend. So that's the only point I sought to make in relation.
Yes, and at every stage you could then be on the wrong end of public law proceedings if you didn't take the next stage to the satisfaction of the complainant.
Exactly.
Yes.
So, pausing here, if the appellant is right, and if the Commissioner is under an unbounded obligation to deal with a complaint that there's been an infringement, if a determination of that question requires all of those powers to be exercised, it requires everything to be done: information notices, assessment notices, going into premises, quizzing people, testing equipment, and so on and so forth. And what we say is that if that's what Parliament intended to do, that's really what it intended to impose on the Information Commission. It had to do so in unmistakably clear language, and it hasn't done so. Then, Turning to Article 58, sub-article 2, which is at page 104 in the bundle, we see listed the Commissioner's corrective powers. There's nothing in them to suggest that the Commissioner must use any of these corrective powers. They are what they say they are, that is to say, powers. And then the next...
I see that in 2A the word likely appears. I haven't found it anywhere else. 58.2a, one of the powers, and I don't know whether it's an exhaustive list or a non-exhaustive list, is to warn that intended processing operations are likely to infringe. And that could point either way, I think, because it's a use of the word likely, but it's a use of the word likely in the context of something that is in the future,
yes,
rather than something that's in the past.
And the warnings and reprimands, which reprimands are in B, are the ones which aren't legally enforceable decisions as we describe them, because they don't give rise to an obligation on the recipient of the warning or the reprimand to do anything. They may be putting themselves at risk if they don't, but it doesn't require them to do anything, and there's no right of appeal against of those under the regulations, as opposed to assessment notice and what have you. So the next provision we look at is Article 77, which is at page 110 in the bundle, and to which my learned friend took to the court this morning. And this confers on the data subject a right to lodge a complaint with the Commissioner. It says in terms nothing of itself about what the Commissioner must do on the receipt of such a complaint. But the next article, Article 78, sub-article 2, does, and it tells us that the data subject has a right to an effective judicial remedy where the Commissioner doesn't handle a complaint or doesn't inform the data subject within 3 months of the progress or the outcome of the complaint that has been lodged under Article 77. Now, Article 77 is supplemented in the way that the DPA supplements the UK GDPR by section 166, which the court has at page 167 of the bundle. This gives the data subject who has made a complaint under Article 77 a right of appeal to the first tier tribunal where the Commissioner fails to take appropriate steps to respond to the complaint and fails to provide information on progress or the outcome. And that's not this appeal. The appellant did not complain that the Commissioner had failed to take appropriate steps to respond to the complaint or that the Commissioner had failed to inform him about the outcome. Otherwise, he would have gone off to the first tier tribunal. The Commissioner did inform the appellant, did respond and informed the appellant of the outcome. The appellant's complaint is that he does not like that outcome. In the Commissioner's skeleton argument, paragraphs 7 to 13, we've set out the two types of outcome to a complaint. The first type of outcome involves the exercise of the corrective powers under 58.2, Article 58.2 that I've just described. And the second type of outcome does not involve the exercise of any corrective powers. There, the Commissioner, having investigated the subject matter of the complaint to the extent appropriate, may not be in a position to determine whether the controller has or has not infringed the GDPR, but has concluded that he has a sufficient understanding that it's not appropriate to bear all of the Article 57.1 investigative powers that are in his armoury, not appropriate to enter the premises and so on and so forth, to go through every possible exemption in Part 2 of the DPA to see if it's applicable, to liaise with the controller and so forth. What happens there is that according to the seriousness of the subject matter of the complaint, how many data subjects are affected, the nature of the data concerned, whether the data subject has achieved in another form vindication and so forth, the Commissioner may conclude that it's not appropriate to carry on investigating until that point has been reached. And that essentially is what we say the answer to ground 1 is. That's all that the Commissioner is required to do. It's to the extent appropriate. And sometimes the extent appropriate may not extend to reaching a determination whether or not there has been an infringement of the GDPR. So with that...
Well, while we've got 166 in front of us, because I don't think we looked at it earlier, again, your submission, as I understand it, is that the tribunals, the entry to a tribunal is where the Commissioner fails to take appropriate steps to respond. That this is another instance in which, had it been said, fails to determine the complaint or fails to determine whether or not there's been a breach of the GDPR, where that form of word would have appeared. And the whole act would have been shot through with that form of word, but that's not what was chosen.
That's not what was chosen, and that's what causes the appellant to bring this claim by means of judicial review. He cannot fall within Section 166. He has got no right of appeal to the FTT. That's common ground. Got no right to the first tier tribunal under Section 166. So there's no question of progressing complaints. So what is said here is that, as Malone and Friend would have it, that hole, that absence, is to be filled in by a claim for judicial review.
Why has he not got a right under 166(1)(a)? I mean, let's suppose the complainant is correct and simply saying, well, we take no further action for these reasons, is not an appropriate step to respond.
Well, the appellant's position here is not that he had any right of appeal under Section 166. He says he had no right under Section 166.
I'm querying that.
I'm sorry, Malone.
I'm querying that.
Well, that's our further reason, that one of the further reasons that we have put forward why this...
I mean, if what you've done isn't taking appropriate steps to respond, then there's a tribunal.
Well, we would agree with that, but the way Malone Friend presents it is he's not captured, his client is not captured by A, B or C, and therefore the only means that he has of securing an effective judicial remedy is by launching proceedings in the High Court.
Right.
But I was a slightly different, although similar point to ask you about on Section 166. If an outcome has to be a determination, then the logic of the argument would seem to lead to the conclusion that Section 166 does capture it, and that the first tier tribunal is the right place to go if the Commissioner fails to do the duty imposed, perform the duty imposed by Article 57. So it doesn't take you very far, because it still puts you on the wrong end of a complaint of that kind. It just says that this is the wrong place to... Well, the High Court was the wrong place to go. So to which your answer is, outcome doesn't mean determination.
Well, the premise of your question is not one that we accept.
No,
if the premise be correct, then that is what we would say.
Yeah.
So, with that introduction of our position, the Commissioner's position in relation to Ground 1, can I answer Malone and Friend's 8 headings? And his first heading, you may remember, was that revolved around the Article 77 right to lodge a complaint. And what was said here is that the word right implies that there is an obligation on the Information Commissioner to determine whether that complaint is well-founded. The answer to that, my lady and my lords, is that no implication is required, because both Article 78 and Section 166 have spoken to what obligation attaches to the right, and it's not a matter for implication to enlarge upon this. That's the short answer to the Article 77 right point, and indeed it may resonate with the questions that have just come from the bench itself. Learned Friend's second heading he described as GDPR policy, and the Learned Friend submitted that the policies are summarised in the recent CJEU judgment, which he took you to at tab 22. That judgment, the court will realise, was driven, and the reasoning in that judgment, by the EU Charter, which is no longer part of UK law. And if we pick up the judgment, which is in tab 22 of the authorities bundle, and starts at page 589. If we go to the paragraphs, in fact, that the Learned Friend took the court, at page 595, it's paragraphs 43, 51 and 57. You see, at 43, the GDPR requires, inter alia, the competent authorities of the member state to ensure a high level of protection of the rights guaranteed in Article 16 of TFEU and Article 8 of the Charter. And then again, in paragraph 51, member states must ensure that the practical arrangements for the exercise of the remedies provided in articles, etc., do not disproportionately affect the right to an effective remedy before a court or tribunal referred to in Article 47 of the GDPR. And then over the page, we see they culminate in their reasoning at paragraph 57, having regard to all the foregoing. The answer to the question referred is that Articles 77, 78 and 79, the GDPR, read in the light of Article 47 of the Charter, must be interpreted as permitting the remedies provided for in Article 77.1 and 78 of the regulation on the one hand and 79 thereof on the other, to be exercised concurrently and independent of each other. And the Learned Friend relies on this, but in fact the reliance is no longer well-founded in this jurisdiction. And it says that the policy of the GDPR points to an obligation to the regulator to decide every complaint. The answer to that is that the Parliament of this country has decided what must be done, and it's not for court or anyone else to gainsay that decision. What Parliament has decided must be done is that the matter must be investigated to the extent appropriate, and has not spoken to whether or not in each and every case the Commissioner must make a determination. And that is, as we say, a read-in that my learned friends write. I should also...
I follow the logic of what you're saying, but is it the Information Commissioner's position that people's data is less secure because of Brexit? I'd be very surprised if that was the case.
No,
the regulation recitals 10 and 11 speak in terms of strong protection for personal data, and I presume that's what you're there for. And so I'm not at the moment very struck by the argument that because there's a nod in the direction of the Charter at various points during the reasoning, that suggests that we've got lower standards.
No, it doesn't. It's not suggesting that. The point of the Charter is relating to the remedies and the extent to which the regulator must act. And you see that in the actual ruling in bold at the foot of 596 that it is driven by Article 47 of the Charter. It's not that the protections given by the GDPR are any less because Article 47 is not part of UK law anymore. It's a question of how these are to be delivered in this country, and that's something to which Parliament has spoken through the DPA as to the adequacy of that.
Yeah. Well, I thought your overarching submission was likely to be that this doesn't help very much in relation to the interpretation of what we've got to interpret.
Well,
The general point, which is that people have more than one weapon that they can pick up in trying to protect their rights, again, doesn't seem to be terribly controversial, but it may apply in certain circumstances differently to other certain circumstances.
But it was my learned friend's second point. His third point was the Facebook decision, which the court has in tab 21, starting at page 455. And again, it's another judgment driven by Article 47 of the Charter. And you see that in the head note, which sets out holdings at 3, 4 and 5, all of which refer to Article 47. But in any event, Facebook Ireland was concerned with the transfers of personal data to a third country, as they are termed, that is to say a country which is not subject to the GDPR. And the fundamental difference with a transfer to a third country in a subject access right under Article 15 is that once the data is in the third country, unless there are adequate protections, the data subject has no right against the controller in that third country. There are no private law rights, and that is what drove the decision in Facebook Ireland. You see that, turn to page 570 at paragraph 111. This is what's driving it, is that unless the regulator controls what is sent into a third country, then there is no ability to get a remedy for the data subject in that third country. And so that's very different from the subject access right. The other point that would be made, that I would make in relation to the transfer right, is that unlike the rights which are earlier on in the GDPR, these are not subject to the exemptions in the DPA. The DPA exemptions, which you see in Schedules 1, 2, 3 and 4, relate to the earlier rights. They do not relate to the transfer right that you find in Article 44 and 46. They are not qualified in that way. It's a much more binary decision that falls to be made when it comes to transfers to third countries. My learned friend took you in the Facebook Ireland judgment to page 572, and it's paragraph 120, where it says, even if the Commission has adopted a Commission adequacy decision, so an adequacy decision is a decision that says the third country has got adequate protections and therefore you can transfer the data over. So even if it has an adequacy decision, the competent national supervisory authority, i.e. the ICO here, when a complaint is lodged by a person concerning the protection of his or her rights and freedoms in regard to processing personal data, must be able to examine with complete independence whether the transfer of that personal data complies with the requirements set down by the GDPR, and where relevant to bring an action before national courts in order for them, if they share the doubts of the supervisory authority as to validity of the adequate decision, to make a reference for a preliminary ruling for the purpose of examining its validity. You can't read that across, we say, to the subject access right with which we're here concerned. It's fundamentally different and would be a fundamental extension of such authority as can be derived from the Facebook Island decision. The next passage my learned friend took you to, paragraph 157, where, that's page 579, where the court said the fact remains in accordance with the case law set out in paragraph 119 to 20. That when a person lodges a complaint with the competent supervisory authority, the authority must examine with complete independence whether the transfer of personal data at issue complies with the requirements set down in the GDPR, and if in its view the arguments put forward by that person with a view to challenging the validity of an adequate decision are well founded, bring an action before the national courts in order for them to make a reference to the court for a preliminary ruling for the purpose of examining the validity of that decision. So it's an obligation to examine to see whether the transfer complies with the GDPR, but it stops short of saying, even in relation to transfer, that the regulator must in every case reach a determination whether or not it does so comply. So that's the Facebook Island decision, which we say doesn't support my learned friend in any way whatsoever. The fourth point that he raised was the right to an effective remedy. That's in Article 78. And again, Facebook was used in support of that. In this case, the learned friend took you to paragraphs 148 to 150 of the Advocate General's opinion, and in particular where the Advocate General spoke of a strict power. We could turn that up, which is in the bundle at page 494. And I think this prompted a question from my Lord Justice Warby as to why the last sentence was there, i.e. the recognition of a right to a judicial remedy assumes the existence of a strict, not a purely discretionary power on behalf of the supervisory authorities. 2 points to be made here. The first is that it was driven by the fact that once personal data is in a third country, that may fail to respect the data subject's fundamental rights. That puts a premium on the regulator into looking into the matter, which doesn't exist where you've got a right which is capable of being enforced in domestic, effectively being enforced in domestic courts. You don't have that same drive on the regulator as you do once the data is overseas, it's overseas. And secondly, the Advocate General, in speaking of a strict power on the part of the regulator, doesn't say what it's a power to do. And the answer is, it's a power, strict power, to consider the complaint. It's not a strict power to make a determination.
I suppose it's an odd phrase in, to us. A strict power is not a strict duty. It's, a strict power is a bit of a strange beast. But that's maybe something is lost or gained in translation.
Yes.
I doubt this was written. I know that they all have the same status, these translations, but sometimes one doubts whether that should be strictly adhered to.
Oh, and sometimes the words have a different nuance, carry different connotations according to the language into which they've been.
Yes, I think one's entitled to consider the legal context in which these terms are used.
Correct. The other authority in support of his fourth point that the learned friend took you to was the judgment at page 490. No, forgive me for that. The learned friend then took you to recital 141 of the UK GDPR, and he made the point this is, although some of the wording in it is no longer appropriate, has been carried over into the UK GDPR. And what we say in relation to
page 37.
Yes, sorry, page 37 of the bundle, my apologies. It doesn't help my learned friend. All it says is that if a data subject considers that his or her rights under the GDPR have been infringed, he has the right to an effective judicial remedy. And the bit of recital 141 that actually relates to the investigation of the complaint is the second sentence, namely, the investigation following a complaint should be carried out subject to judicial review, importantly, to the extent that is appropriate in the specific case. And that, of course, wording that is mimicked, or rather reflected, in the relevant provision of the body of the GDPR itself. My learned friend says, in his phrase, it's blindingly obvious that this means that the regulator must determine every claim of an infringement and reach a determination. But it's, with respect to my learned friend, it's wishful reading of this provision to say that this imposes such an onerous requirement on the regulator. It doesn't say that, and it's a wishful reading on his part. So that's the fourth point. The fifth point that is made was from Article 57(1)(f), which we've already looked at when I opened my submissions, and we have turn to it, page 102 of the bundle. And I'll be forgiven for repeating myself, but in answer to this point, we've seen that Article 57(1)(f) says to investigate the subject matter of the complaint, and it doesn't say, or even imply, that the regulator must determine whether there has been an infringement.
I think you've told us this. We've got your submission about this.
So,
I think you made three observations, which
yes.
we.
So I won't repeat that. That's my answer to his point 5. Point 6 concerned Article 79. That's the rights against the controller or the processor, but in this case it would be the controller. And learned friend, in answer to a question from my Lord Justice Peter Jackson, says that if there's a concurrent private law proceedings, if there were, and wasn't in this case, but if there were, and I think your Lordship spoke of this gigantic claim which is going to be resolved in 2 years' time, nevertheless the Information Commission would still have to go ahead and make a determination, notwithstanding that that was an issue that fell to be resolved in those private law proceedings. Our system of law has an instinctive aversion to concurrent decision making, which may result in divergent decisions on exactly the same breach. It has that instinctive aversion because those concurrent decisions, if they diverge, diminish the position of the judicial body and the regulatory body. It diminishes both of them. And it also begs the question, why, to have an effective remedy, a data subject should have 2 concurrent opportunities to have exactly the same issue resolved? Begs the question. The learned friend doesn't supply the answer because there is none. And again, it's one of those factors which, in interpreting these provisions, the question of which interpretation should be preferred, bearing in mind there are not the words in either the GDPR or in the DPA that give a definitive answer. The 7th point my learned friend raised was the legislative history. And the court will have picked up, as indeed evident from the questions of my learned friend on this, that we have nothing really to say in support of the provision that, the point made in the judgment that this was a reenactment. It wasn't a reenactment, we know that. And my learned friend is correct in observing that the DPA 2018 is not consolidating legislation. The reference to that in the judgment was a distraction. The basic correctness of position, nevertheless, was the same, and it was unnecessary in order to reach that conclusion. The final point raised by my learned friend was the point of resources. And I've already made my submissions on that. This is not a matter where you need an appropriation that is met by an appropriation. And I've made the point in relation to section 137 of the DPA as to how it is to be funded. So unless there are further questions, those are my submissions in relation to ground 1.
No, thank you.
And I move on to ground 2, which really is a rationality challenge. And it is a fallback position on the part of the appellant. So it proceeds on the footing that under Article 77, where a complaint has been lodged, the Commissioner may respond to the complaint without necessarily making a determination. And we have set out in our skeleton argument what can be done in these circumstances. That's paragraphs 9 to 13. And the way my learned friend put it this morning was to sort of move away from a standard rationality challenge, for a reason one can entirely understand, and to say, well, there's an absolute duty on the Commissioner to go about this in the right way, and that hasn't been done. Now, yesterday, added to the bundle, core bundle, which I understand the court has, were 2 documents at pages 189 to 191 and 192 to 194 respectively, which, if I could ask the court to look at, really put pay to this in a practical way. 189 is the complaint that the appellant's solicitors made to the Information Commissioner, and you'll see there that it records the history of the appellant's data subject request on the 19th of November 2020. It records that on the 18th of December, the controller purported, as they put it, to reply to the subject access request, provided only a very limited set of documents. And then the next paragraph, paragraph 5, refers to earlier correspondence from the solicitors, the 18th of January. They say explaining to the controller that its response was inadequate, not in compliance with the law. And you'll see there in subparagraphs A and B, it sets out other categories of personal data, that TransferWise, and explaining why TransferWise had decided to close the appellant's account and which were the exemptions applicable. Paragraph 6 sets out the controller's response. Over the page, paragraph 7, we see that on the 15th of February, Thames Valley Police had written to the data subject, the appellant, informing him that it was conducting an investigation into the source of his funds held in an account at the controller. The only possible way that the police could have been aware of these funds is through being alerted by the controller. Our client considers that such an alert was almost certainly effected through the filing of a suspicious activity report with the National Crime Agency. We see that there was further correspondence, so on and so forth. And then in paragraph 10, we see that the solicitors for the appellant disagree with the controller's position. And there's a mistake, incidentally, on the 4th line. It's not the 20th of November 2021, it should be the 20th of November 2020. Anyway, they say the response is inadequate, and they explain why. And you'll see in B, just towards the bottom of page 190, they say, to the extent the exemption it relies upon is the exemption for the prevention and detection of crime, there is no basis for that. TransferWise may have become aware through public sources that our client has been indicted by the US Department of Justice for breaches of the Banking Secrecy Act. But of course our client is aware of that, so there's no way in which withholding his personal data from him would be useful for the prevention or detection of crime. So at this point, the appellant's solicitors are aware of what the exemption is likely to have been that animated the decision by the controller not to disclose the personal data. We then turn to...
Just before we leave this, there was a bundle of documents was sent along with this, and from the internal information it appears that there were at least 29 pages in that bundle of documents. What you were presented with was not simply the complaint, but all the material that pre-existed it.
Precisely. And also an indication of what the exemption was that was being relied upon by the controller. So when
would the inference be that that exemption was also being relied on as a reason for not disclosing the nature of the exemption that was being relied on? This is basically an anti-tipping off kind of point, isn't it?
Yes, you sometimes...
The point they're making in the passage you just read to us is there's no anti-tipping off purpose here.
Yes, so the submission made by my learned friend this morning is this is totally inadequate, the response of the Information Commissioner, because he hasn't even asked the controller, what are you relying on, why are you doing this? And my response to that is, well, this is the complaint that was given to the ICO. That complaint itself with the attendant material explained what the backdrop was. And the question is, given that all of this material had been given to the Information Commissioner, was it unreasonable, irrational, or improper approach the Information Commissioner to decide the way that the Commissioner decided, I've got enough, without going back to the controller and saying, why did you do what you did? And our answer to that is, you can see perfectly clearly from the material that the appellant himself had proffered, or his solicitors had proffered to the ICO why the controller did what the controller did and why the controller did it. It didn't have to go and ask again, to go and repeat itself why it did that. And that's borne out by the other piece of correspondence that my learned friend put in, which is actually the first decision. This is at page 192 of the Information Commissioner. The 12th of October 2021, and it sets out at the foot of that page what the complaint is. You've made a subject access request to TransferWise, not satisfied that you've received all of the personal information you believe you're entitled to receive, and specifically you haven't, the controller hasn't told the appellant the reason why they closed his account, not a matter for the Information Commission, needless to say, and what exemptions they have applied in processing the appellant's subject access request. Then it sets out the Commissioner's view, and we see there the fourth paragraph, just near the second punch hole. They refer to the correspondence, or sorry, the Commissioner refers to the correspondence provided. If the correspondence provided, he writes, there is reference to the prevention of the crime exemption. I'm assuming that this is the crime and taxation exemption. Pausing there, that's paragraph 2 of Schedule 2. If TransferWise are relying on this exemption, the list of provisions in Schedule 2 of Part 1 of the DPA, that's the provision that says these are the applicable provisions to which this exemption applies, including the right of access, do not apply to personal data processed for any other purposes to the extent that the application of those provisions would be like prejudice any other matters above. The organisation, the controller, is not required to tell an individual what exemption has been applied and why this exemption would undermine the exemption, for example, in prejudicing a criminal investigation. And it's perhaps sensible at this point to look at the exemption itself, which we have in the bundle. It really starts at page 169, and I don't know to what extent the court is familiar with the way these exemptions work, but schedules 1, 2, 3 and 4, in particular schedule 2, are split into parts. So we see part 1 starting at paragraph 1, and it runs down, I think, to paragraph 5. And it says in paragraph 1, these are the listed GDPR provisions, and we see in Roman 3, it includes Article 15, so that's the subject access right. So these get various disapplications. You get the same in part 2, there are different GDPR rights, same in part 3, part 4, part 5 and part 6. The relevant one is paragraph 2. So the listed GDPR provisions, read Article 15, and Article 34 of the GDPR do not apply to personal data processed for any of the following purposes, and then we see A, B, or C, prevention or protection of crime. But it's a provision which is limited to the extent that the application of those provisions would be likely to prejudice any of the matters mentioned in paragraphs A to C. So you've got a prejudice-based exemption which applies in any of A, B or C. And again, to revert back to my first ground, you immediately realise how deep and intensive it can be for the Information Commissioner to reach a determination whether this exemption or any of the other exemption applies. You've got to make that judgment call. But to return to my learned friend's point, the rationality challenge, what's said here is that it was irrational for the Commissioner to reach the conclusion that he did and the way he went about it because he didn't have the material necessary to reach that conclusion. Well, the answer to that is provided by the documents that were put into the bundle yesterday. And with that, the rationality challenge really does fall to one side. Unless there's anything further, that's all that I wish to say in relation to the second ground.
Thank you.
That then takes me to my additional grounds, my two additional grounds for dismissing the claim. The first is that the appellant had an alternative remedy, and we pick that up in our skeleton at paragraphs paragraphs 49 down to 64. Now, this was raised in the court below, and the judge dismissed it as a point. And it has two limbs to it. What we say is that the appellant had a right, or that the judge wrongly read down the data subject's right to make an application to the FTT under section 166. And this feeds back into the question that came from the bench about 30 minutes ago about the nature of this right. Or if it is the case that the data subject has an absolute right to get a determination from the Information Commissioner, if that be correct, if that is the correct reading, then under section 166, if that hasn't been reached, if the Commissioner has stopped short of doing that, then the Commissioner is within section 166. So just to return to that provision itself, which the court has at page 167 of the bundle, if the premise is correct, that the Commissioner has to go all the way in dealing with a complaint and make a determination whether there has been an infringement of the data protection regime, then if the Commissioner hasn't done that, the Commissioner has, under paragraph A, subsection 1661, quote, failed to take an appropriate step to respond to the complaint. So if the premise is correct, then the remedy for the data subject, there is a remedy for the data subject, a fuller right to the FTT under section 166. And the judge was wrong to read that down as being less than that. The way that
Can we just unpick this by stages? You only need this if you lose on ground one.
correct.
And I'm just interrogating myself as to, in the world where you have an obligation to investigate everything, then you say, in those circumstances, for you, the saving grace is that people have got to go to a tribunal rather than the High Court. But it might not be a complaint that you had just done nothing at all, but that the things that you had done were insufficient, and that there's more that you could have done to make it appropriate, and so on and so forth. So there's a spectrum of possible complaints that might arise at that stage.
Yes, and the particular one which is made here against the Commissioner is the Commissioner must, every time the Commissioner gets a complaint that there's been an infringement of the GDPR, the Commissioner must reach a determination whether there has been an infringement. So we didn't hear, that's an agreed position. If we didn't hear, and that is the obligation, if I'm wrong in relation to ground one, then the Commissioner has failed to take appropriate steps to respond to the complaint because the Commissioner has not made a determination whether there has been an infringement. So the appellant goes in under subsection 1A of section 166. He has an alternative remedy, and it's indisputable that if you've got a full right of appeal before the FTT, then you do not seek judicial review.
And following on from my last question to you, 166 is orders to progress complaints. I mean, clearly that could be appropriate if simply very little was done. There's a specific paragraph for nothing done in 3 months, no reply in 3 months. But failing to take appropriate steps in the context of orders to progress complaints, the fact that you closed your file after taking a certain amount of action, you said, that's our decision. That's the end of it. Would it be possible for somebody to come back under 1661 in your submission and to say, well, you dismissed my complaint or took no further action on my complaint without taking appropriate steps? So the fact that you had closed, in other words, not that you'd simply not decided the complaint, but that you'd actually decided it by no further action or by dismissal or whatever it was happened to be, could they still come under 166 in your view?
In my world, no. In my learned friend's world, yes.
Yes, all of this is premised on you having been unsuccessful on ground one.
Because in my learned friend's world, appropriate steps involves making a determination whether there's been an infringement.
Right, and from memory, the judge's decision was, as it were, this was to do with procedural matters during the course of an investigation.
Yes, his reading was that the right of appeal under section 166 was that once an outcome had been pronounced, I think is the way that he put it, in paragraph 128, once an outcome has been pronounced, then you can't make an application under section 166. But in a sense, that doesn't deal with what I call the antecedent question.
It's question begging. It's question begging. The point that I raised earlier was that another way of analysing this, and possibly an additional way, is that if an outcome means a determination, then section 166 subsection 1b would kick in. Is another way of putting your point, but on the appellant's argument,
yes,
an outcome must involve a determination.
Yes,
there's no other possible outcome.
Correct.
And then it would all make sense, but it would be unhelpful. But what's your submission about if this is right and we're against you on ground one, and this submission comes in, what do we do about the fact that the judge has made a decision on the merits? Because on this analysis, the judge shouldn't have been making a decision. We shouldn't be making a decision because it's all a matter for the first tier tribunal. That seems a bit artificial given where we are. Is this just a point about costs?
If I'm right about this, so okay, if we're both right, my learned friend's right in relation to ground one, I'm right in relation to section 166, and the question, what should be done about it?
Yeah.
Putting oneself in the position of the appellant had a right, as this court would find, if I'm right on this point, to go off to the first tier tribunal, and the question is whether that right, notwithstanding the passage of time, is restored so that he could have a merit review in the first tier tribunal. And thinking on my feet, that's, I think, what the outcome would have to be. It would have to be that the judge's decision below is overruled in this regard.
Right, but anyhow, the appellant got permission for JR, and this argument was not presented in opposition. I think that's the history of it, isn't it?
Just bear with me, as I wasn't involved. It wasn't put in until after permission to grant.
Exactly.
The relief one.
Yes, but I mean, in a sense, I'm not seeking to be clever about it in a sense, but this is an argument which might have had its biggest heft if it had been put in response to the application for JR.
Yes, you might characterise it running the gangplank after the ship had left. But there we are.
Yeah.
So that's the first alternative remedy. The second, and that's on all fours with what my learned friend says the Commissioner should be doing. The second remedy, alternative remedy, is that of a private law remedy against the controller. And my learned friend says, well, that's a different matter. That's private law remedy, and this is regulatory remedy. You have to ask yourself, what is the regulatory remedy concerned with? What the regulatory remedy is concerned with is whether the private law, whether the rights of the data subject have not been respected by the controller. That issue will be fairly and squarely decided by either the county court or the high court in a private law claim. There is no lesser consideration of the issue which animates the complaint that has been made to the Information Commissioner. So it is in that forum, it is in that venue that this issue, i.e. there has been an infringement of the data protection rights of the controller, can be definitively decided by indeed the two parties best able to grapple with them, namely the data subject and the controller. The only point really that is made and why a claimant would prefer to get a ruling or to get a definitive decision by the regulator is that, of course, it's free of charge. That's really what's driving that in some circumstances. But it is an alternative remedy. It's one which has been provided for and which is spoken to in both the GDPR and in the Data Protection Act. And we say that the judge was wrong to disregard that as a remedy itself. It is not an inadequate remedy, and it is, as I say, a complete remedy for all the reasons that we set out in paragraph 58 down to 63 of our skeleton argument. So just drawing those together, we say that together and individually, these provide yet a further reason why the judge should have dismissed this claim for judicial review. The second additional reason we have is that the challenge was, by the time it came to the court, a purely academic challenge. And we deal with this in our skeleton of paragraph 65 down to 78. And the reason that it was a purely academic challenge is that by the time it got to the High Court, the controller had given the appellant all of the documents that were captured by the Article 15 request. There's nothing left. And our point here is that in dismissing this point, which was run before him, twofold. First of all, the judge accepted that it was an academic point. And you see that in paragraphs you see that in paragraph 121. It is academic, contrary to what my learned friend submitted this morning. But what the judge said, and what we take exception to, is that it would be in the public interest, nevertheless, for the claim to be heard, because the question had not been directly considered either in domestic or European case law in the years since data protection came into existence, or in the 4.5 years since the EU GDPR became law. And you see that set out in paragraph 122 of the judgment. And our point in relation to this is that the question had in fact been touched on, certainly by the upper tribunal, by Mrs. Justice Warby in the Killock judgment, where the upper tribunal considered GDPR Article 57, 1F and 77, and a later decision of Scranage. And both of those were in the bundle of authorities that were before the judge. And what we say is they had been considered by the upper tribunal, and in the scheme of regulation, the tribunal system is central to the data protection regime, and of course includes the upper tribunal. The judge was wrong, we say, to exercise his discretion to hear what was an academic claim on the basis that the question hadn't been considered in the courts, when in fact it had been certainly touched upon by the upper tribunal.
Do we need to look at Killick and Scranage, because we haven't been there. We haven't been there yet, because I'm not expecting much sustenance in the sense of the question that we have in front of us, as I'm sure we would have got to them before 3:30 in the afternoon. So what do they tell us?
Well, you have Killock, which is reported in the weeklies, tab 25, page 623.
Thank you.
If we turn to that.
So can you give us the headline before we...
Yes, so the headline from that is that the Information Commissioner there had declined to investigate to the extent required the applicant's complaint on the basis that it lacked merit. In other words, akin to what we are here involved. And the applicant had applied to the tribunal under section 166 of the DPA. And the first tier tribunal had directed that the point be determined by the upper tribunal, in the words of the first tier tribunal, so that the upper tribunal could provide authoritative guidance as to the extent to which the Commissioner's obligations to investigate a complaint made by a data subject under section 165, 166 could be considered. And the principles are set out in the upper tribunals, having been so referred, decision at paragraphs 107, page 653, down to 117, and it culminates at the end, paragraph 117, with the tribunal's conclusion that in the circumstances, that's where the Commissioner simply declined to investigate a complaint at all, where the Commissioner has failed to take appropriate steps to investigate the subject matter of the complainant's complaint, the tribunal may make an order under section 1662A but not otherwise. So just returning to the previous paragraph, they say section 166 is a procedural, not a substantive remedy which provides for a right of appeal to the FTT on process where the Commissioner fails to address a complaint under section 165 in a procedurally proper fashion. However, as we've concluded above, the appropriateness of the investigative steps taken by the Commissioner is an objective matter which is within the jurisdiction of the tribunal and is not something solely within the remit of the Commissioner to decide for herself. Our judgment, by misconstruing and misapplying her own service standards, and thereby simply declining to investigate the complaints at all, the Commissioner did not take such steps as were appropriate to respond to the complaint. And that, in a sense, harks to the question that was asked by the bench, where the Commissioner does absolutely nothing, doesn't investigate at all, then you do get into the jurisdiction of the first tier tribunal.
And so the reason given, top of 654, taking account of the delay, we do not intend to take any further action in relation to this matter. Top of
Your Lordship say 654?
I heard, yeah, yes, I've gone back to paragraph 100 and it's in paragraph 108. Towards the end of the quoted
yes,
passage.
so quoting from the information.
Yes, this is what was found to be inadequate.
Yes, so we're not incepting an investigation of the complaint on these grounds. I'm doing nothing to investigate.
Yes,
and so how does this relate to the judge's decision? Well, what we say is he was not right in saying, let's consider what he said was an academic claim, because it's never been considered by a court in this country. It had been considered by a court in this country. It may not have been exactly on all fours with what held to be considered in the particular appeal, but it was a consideration. It was a detailed consideration of the legislative scheme. And secondly, we say the decision to deal with what he recognised was an academic claim should have been driven by the court's own judicial review guide. That's my point at paragraph 76. And that is, there needs to be exceptional circumstances, and the examples given in the guide are there are a large number of cases that are behind it or may exist or be anticipated. And that conforms with the guidance which has been given by this court in the Heathrow Hub judgment, which we cite at the foot of page 23 of our skeleton, page 208 to 210. And in this case, there were no large number of other cases, whether existing or anticipated, that had been identified by the judge. This was Mr. Delo's case, Mr. Delo's case alone. And we've seen from the complaint that was made from the Information Commissioner and the correspondence from the Information Commissioner just what was at stake here. That can't be translated to every other complaint that is made to the Information Commissioner in relation to a data subject request.
Did you want to show us scrannage, or is that?
I'm sorry.
Did you want to show us scrannage? Because I'm just having momentary difficulty in locating it.
It's not an abundance. I don't know. Sorry? Yes, so scrannage is not in the bundle, but it is cited in Killock.
Yes.
I think that's why it hasn't been put in the bundle. Just bear with me.
Paragraph 642.
Yes, so yes, page 642, starting at paragraph 60. And you'll see the language which gets repeated later on in the decision in Killock, namely section 166.
Right. So this is the procedural versus substantive dichotomy which the judge himself relied upon.
Yes, so this is, it's a procedural thing, it's how you've gone about it, rather than the thing that comes out at the other end.
Well, now, this is all interesting, but where does it leave us? I mean,
where it leaves this court is we ask ourselves for this second additional reason: has the judge properly informed himself and applied the provisions relating to how we deal with an academic claim?
yes, all right. So let's suppose he's wrong, but he was right that it was academic. He was wrong that it was very important. So where does that leave his decision, which you seek to uphold?
Well, it leaves us that there was yet a further ground why this matter is not one that was should have been subject.
Yes, but then you'd be worse off. I mean, if you're saying that he should never have got into this, he shouldn't have made his decision, then you'd have been deprived of a decision which you have been sustaining under ground one, namely that you don't have to investigate everything.
Yes, but if
I'm trying to work out what.
Well, if the court's against me in relation to ground one, ground two, if you're against me in relation to those, what I say is this.
So we're against you, and we consider that you ought to investigate everything. You then say, but you shouldn't say so because it's academic.
We say it shouldn't have been embarked on because it was.
No, but it has been embarked upon.
Well,
because there's been a hearing, and now there's been an appeal, and so. I mean, what are you suggesting we should do in practice? Just pack up and go home?
No, never.
No, but I mean, so at the moment I'm not understanding it. You might be, let's suppose you're right at every stage of the argument on respondent notice 2. Still, where does that?
All it leaves is for certain observations to be made by this court. That's all I would suggest.
But I mean, having got this far, it would seem to be feel very difficult for us not to express a view as to, at least as to ground one.
You're asking us to discourage other judges from taking a similar approach to
give guidance to other judges is the way that I would prefer to put it.
So you're not saying, and we've gone through all this, and then we've been greatly struck by Mr. Philip Coppell's second point, and actually we think that it's all very academic and we're not going to say anything about it.
No,
I mean, that's not a proper way of.
I wouldn't care to see a judgment in those terms. I don't think anyone would. But there are.
Right. So this is, in a sense, is a historic part of the case, which may have implications for other cases if we say anything about it.
Exactly. I mean, this
understood
is unlikely to be the last time that the Commissioner finds him or herself, as the case may be, involved in cases like this. It's a jurisdiction which is full of unanswered questions, and it's only right that this court gives guidance as to the times when it is appropriate for the High Court to embark on judicial review. Unless the court has any further questions.
Just a minute. We don't, thank you,
Can I just turn around?
Yes, quite, and I will too.
No.
Was there anything else?
No, nothing from me.
No. Well, thank you very much. We're just going to rise for 5 minutes. Don't go too far, please. Yes, Mr. Copper. We'll hear you now in relation to any reply on your grounds of appeal. And if there's anything you want to say in relation to either of the respondents' notice points, we won't stop you, but we don't need to hear at any great length in relation to those matters.
Well, let me just take the respondent's notice points briefly. I'll deal with my learner friend's points in reverse order, or his submissions in reverse order. So the academic argument, entirely agree with the thrust of the questions asked by the court, but my learner friend is simply wrong to submit that the issue for this court was touched on in Killick and Veal or any other case. And what he hasn't explained to you, and he hasn't shown you Killick and Veal at any length, or as he should have, what he hasn't explained is that he is asking you to overrule Killick and Veal, and indeed to adopt entirely the opposite position for which the Commissioner successfully argued in Killick and Veal. So, albeit it's the very end of this case, it's quite an important point so far as tribunal practice is concerned. But on the academic point, no error of principle by the judge in coming to the view that the important point raised by this case simply had not been determined, and we say not even touched on in Killick and Veal. The alternative remedy then, and looking at the statutory remedy under section 166, and I won't make submissions on this at the length that I might have intended, but Killick and Veal is an authority which does, I'm afraid, repay careful study. You were given an incomplete account by my learned friend. This case actually, which is page 623 of the authorities bundle, concerned 3 separate complaints ruled upon by the Commissioner. In one complaint, the Killick and Veal complaint, the Commissioner had closed the complaint without reaching a determination, he said, because he was conducting a broader inquiry into the industry in that case. And no point actually taken here that the Commissioner was obliged to decide the Killick and Veal complaint. EW was the case that Mr. Coppell did tell you about, which is one where the Commissioner had rejected a complaint on the grounds that it was brought out of time when it hadn't been out of time according to his own service standards. And C was a complaint where the Commissioner had rejected the complaint for lack of merit. Various factual issues raised, and the key point for which the Commissioner forcefully argued in this case is that section 166 confers a procedural remedy which is exercisable at any point up to the issue of a decision by the Commissioner, but not afterwards. That is, I want to get to that, so I'll just give you some references. Paragraph 76 and 77. I should also say paragraph 74 at letter D on page 646. So 74D, 646, 76, 77.
I was just looking to see whether Killick was referred to before the judge in our case.
Yes.
Yeah.
Yes.
Sorry,
Killick was the primary basis for his.
Yes, I'm sorry. The search hasn't brought it
Oh,
up.
I'm sorry. Whereabouts?
129.
126 onwards.
Thank you very much.
And then 129 is the reference to Killick and Veal.
I see.
And so it's 87 on 1649 then, and can I just read a little bit of that? Section 166 is a forward-looking provision concerned with remedying ongoing procedural defects that stand in the way of the timely resolution of a complaint. And then on the Killick-and-Veal case itself, paragraph 100, the Upper Tribunal agreed with Mr. Milford for the Commissioner that the Commissioner had issued an outcome to cease handling the complaint but continue with the wider industry investigation. The Commissioner had acted in accordance with her duty under Section 165, and the quality, adequacy or merits of the complaint outcome fall outside the scope of Section 166 and outside the jurisdiction of the tribunal. Now that line in the sand, as it were, the issue of the Commissioner's decision at the end of his investigation, is straightforward, easy to understand and apply. What the Commissioner's new position, different from what he advanced in Killick-and-Veal, is today, is that the court has to look at, or the court or the tribunal has to look at the outcome decision and decide whether what the claimant is complaining about is a defect in the outcome decision, which is not a procedural, which is or isn't a procedural defect. So for example, the Commissioner failed to take into account a relevant consideration. Well, is that procedure? Is that outcome? Is that Section 166 tribunal, or is it judicial review? And one gets into very difficult questions, which one might not know the answer to until the Commissioner has given his evidence in whatever proceedings there are. A recipe for confusion and multiplicity of proceedings, and indeed of claimants losing their right to complain because they adopted the wrong route. And applying that to our case, as the judge held, Mr. Delo's had received an outcome in his case, albeit that the quality, the merits, etc., of the outcome he contended left much to be desired, because the Commissioner simply hadn't done what the legislation required him to do. That's a challenge to outcome, which, according to Killick-and-Veal, is judicial review, not tribunal.
Thank you.
Now, on ground 2, my learned friend took you to the complaint made by Mr. Delo, which we added to the bundle yesterday, and he said, based on page 190 of the core bundle, that the complaint explains the backdrop to the dispute with TransferWise, and he said you can see perfectly clearly from the material why the controller did what the controller did and why the controller did it. Well, we say with respect that is entirely wrong. One cannot see from the complaint what data TransferWise withheld, because it hadn't told the complainant what data it had withheld. The complainant relied, in paragraph 10 of the complaint, referred to the prevention of crime exemption at 10b, but on the basis that TransferWise had failed to specify the exemption which it was relying on. So it was guesswork, an informed guess, but it was guesswork by the complainant as to what had been relied on. And when one comes to the first decision at 193, which my other friend also relied on, he referred you to just below the second hole punch. Within the correspondence provided, there is reference to the prevention of crime exemption. I'm assuming this is the crime and taxation exemption. And then if TransferWise are relying on this exemption, if they are, and of course nobody knew whether they were or not. And then at the bottom of the page, the organisation is not required to tell an individual what exemption has been applied and why, if this would undermine the exemption, for example, in prejudice and criminal investigation. But nobody knew whether that was TransferWise's position or whether there was any substance to it or not. So the idea that this was enough, that the Commissioner had enough to decide that there was likely compliance, and that was sufficient to close the complaint, we say is simply misconceived.
So how does it go? Let's suppose they'd sent a message to Wise, who'd sent a message back which said it's the criminal and taxation exemption. Where does it go from there?
So they would have been asked at the next stage, what personal data did you withhold and why? And they would have said, here's what we withheld, and we relied on the crime and taxation exemption. And the Commissioner may have enough from that correspondence to make a decision one way or the other, or he may go back to Mr. Delo and say, well, look, now we know, now we've been told that it is the crime and taxation exemption, and here's broadly what the argument is. But one wouldn't necessarily have had to have gone very much further than where the Commissioner did go to reach a decision.
Well, I'm just testing how far your argument goes, that in this particular case, had you simply got another letter from the Commissioner saying, I've checked and it is what we all think it is. That's it, is it?
Well, the question then arises, is that sufficient for the Commissioner to make a decision as to whether there has been an infringement or not? It may have been, and there will be cases where simply writing to the data controller, as the Commissioner says he would usually do in the guidance I showed you, there will be plenty of cases where that produces a response which is sufficient for the Commissioner to make a decision. Nobody's suggesting that, as Mr. Coppell put it to you, the Commissioner has then to run through every single exemption in Schedule 2 or whatever and consider every possible breach apart from the one that the complainant has mentioned.
But what, I mean, in this case, I imagine that the data subject's concern was that there were unfounded suspicions about his behaviour with money. And it's most unlikely that someone in that situation would be satisfied by a bland response saying, well, this is the exemption we relied on. They would naturally want to know, well, on what basis did you apply that exemption? Because it's qualified as a prejudice-based exemption, and you've got to explain what the prejudice is.
So I am suggesting that the Commissioner should have asked TransferWise, what did you withhold? What exemption did you rely on? What was the prejudice? And then the Commissioner would have considered that response, and that may have been enough.
So it would have been a detailed explanation of what had been done and why.
Yes.
On what
yes.
factual and legal basis that had been done.
Yes. A detailed explanation to be provided to the Commissioner.
Yeah.
And of course one sees this in FOI cases all the time.
Obviously it can't be given to the data subject unless the Commissioner decides that it has to be, and then there might be a challenge to that. So.
In some cases it won't be possible to say very much to the data subject, I agree. So not very much more necessarily had to be done, but certainly more than this. So that takes me then back to ground one. My learned friend started his submissions with resources. I can't answer the detailed points he made about the breakdown of the figures and this group of complaints fell into this category. I simply don't know what he was referring to. I had a quick look at the annual report. I can't see it, so I'm at a disadvantage. My Lord Justice Warby made what we submit as potentially important point that given the origin of this legislation in the EU, one cannot assume that the particular circumstances of the UK regulator, so how it is funded, what its previous practice might have been under predecessor legislation, one can't assume that that was any driver for the wording of the EU-wide legislation, as one might perhaps have had regard to if it was UK legislation. And no indication then, well, certainly the relevant provisions were not changed by the UK legislator when there would have been an opportunity to do so if it was desired to bring the UK circumstances particularly to bear. And my learned friend made a number of points to play up the scale of the task which might face the Commissioner if he was required to decide on infringements. One small point I wanted to correct him on with respect is he said that the Commissioner would have to investigate even in cases where the controller had rectified matters, which as he said in his breakdown of cases, there is a category of cases where the controller agrees to do things differently. But that wouldn't require a further a decision on infringement or not, and that is because the right to complain in Article 77 is a right to complain that the processing of personal data infringes the regulation. So it's not an historic. There was a breach at some point in the past, now rectified. It is an ongoing infringement, such as I haven't been provided with my subject access data. My data is being processed in an unlawful way.
So does that mean that if you had received your data back, or you received your data earlier, it wouldn't have been possible for you to complain in this case?
Well, if Wise had provided us with the data...
No, but let's suppose they didn't provide you with it, but you complained, they immediately provided you with it, then the complaint falls.
Well, we complained to the
Is that what
Commissioner.
you're explaining to us?
Yes, if that had been immediately rectified,
It doesn't apply because they provided the information sometime after the complaint was dispatched.
Yes, but there will be a category of case which the Commissioner can resolve through agreement, which need not then be pursued to the ultimate decision. My learner friend said, well, there is nothing to suggest that cost constraints are not an appropriate matter to be considered when deciding the extent of the investigation which is appropriate. And there is something to suggest that in recital 110. But really, and it became more and more clear the longer my learned friend focused on resources, that ultimately this is what is driving the Commissioner's position in this case is lack of resources. It's too much work. That is absolutely central to the Commissioner's case, and that is, we say, a simply irrelevant consideration when it comes to construing this legislation. And recital 110 makes that clear.
Just wanted to ask you, Mr. Coppell, about section 137, which I think the other Mr. Coppell, if I can call him that, referred to in his submissions. You don't seem to have the whole of section 137 in the bundle. Section,
DPA 2018.
yeah, tab 6, page 155. So we've got subsection 1, which gives the power. Gives powers to the Secretary of State by regulations to require controllers to pay charges to the Commissioner. We haven't got the rest of the subsection, and at the moment I'm not quite sure how this is relevant, how this relates to anything. But
Well, let me read to you. 137.4 will provide the whole section, but it case until my learned friend's submissions.
Right.
137.4, in making regulations under subsection 1, the Secretary of State must have regard to the desirability of securing that the charges payable to the Commissioner under such regulations are sufficient to offset expenses incurred by the Commissioner in discharging the Commissioner's functions under the data protection legislation under the DPA 98.
Right.
Various other
So it's not an overriding consideration, it's a relevant consideration when the Secretary of State makes the regulations about the fees. So it's the Secretary of State has to pay attention to the desirability of securing that, but he isn't obliged to secure it. Is that or have I misunderstood it?
That's right.
Yeah.
It is desirable that the Commissioner's costs are covered by his fees.
Yeah,
And that's
but it's a
one
matter
factor.
for the Secretary of State to decide.
Secretary of State. And of course, if there's a shortfall,
Yeah.
then that will come from central government. My learned friend then moved on to make further submissions about the meaning of investigate to the extent appropriate. But what he said about that, quite fairly, is that the legislation leaves at large appropriate to what? And that is correct, we respectfully agree. But what that reveals is that investigate to the extent appropriate doesn't help one on the key point of construction in this case, because you need to know the answer to the key point of construction, whether the Commissioner has to decide on infringements, in order to know what degree of investigation is appropriate. So far from being, as the judge thought, and as my learned friends had submitted, at least until this afternoon, far from investigation to the extent appropriate being the answer and the clear words that tell us that the Commissioner doesn't have to decide, they actually beg the question, beg the key question that we pose as to whether the right to complain includes the right to receive a determination on infringement. My learned friend made submissions then on Article 58 and the various formal powers of the Commissioner, including information notices, 58.1a. But of course, the Commissioner very rarely resorts to these formal regulatory steps in order to obtain information from data controllers. In the vast majority of cases, he will write to the data controller saying, "I've had a complaint, please can you help me with this?" And the data controller will, of course, comply because it doesn't want a notice against it. So I'm just not sure where that really takes us. The policy underlying the GDPR and the case of BE, yes, there is reference to the EU Charter of Fundamental Rights, but in the judgment. But each of the recitals relied upon by the court in that case is still in the UK GDPR.
You say it's a for completeness reference.
Yes.
To the TFU and the Charter.
The Charter. And there's a reference to Article 7 of the Charter, which is the right to respect for private life, which is of course the same as Article 8 of the ECHR, to which we are still, for the moment at least, bound. Facebook Ireland. My learned friend made a new submission this afternoon, maybe none the worse for that, but a new submission that the reason the explanation for the robust approach taken by the Court of Justice in Facebook Ireland was that the case was about transfer of data overseas, and once the data has gone overseas, then there's no remedy against the data controller. So all the more reason why the supervisory authority has to take a firm view at the prior stage, prior to transfer. The Court of Justice simply doesn't say that anywhere in its judgment. It simply doesn't tie its reasoning to that point, and there is no suggestion that the dicta of the Court of Justice that I showed you, to the effect that the supervisory authority must ensure the enforcement of the GDPR, paragraph 108, or that the GDPR is to be fully enforced with all due diligence, paragraph 112. No hint that that is only in the case of transfers of data overseas, because, as the Commissioner put it, if it stays in this country, you can sue the data controller. And what became more and more apparent in this submission of my learned friend is that he's back with the argument that because you can go to court against the data controller, that makes everything less onerous for the Commissioner himself. And that's simply not the law, and can't be imputed to the Court of Justice. The explanation for the detail on page 579, paragraph 157, the authority must examine with complete independence whether the transfer of personal data complies with the GDPR, and then bring an action before the national courts. The explanation for that is because there was an adequacy decision made by the Commission saying that it was fine to transfer data to the United States, and if you want to challenge a Commission decision, you have to get the case referred to the Court of Justice for that challenge to take place. That's the particular facts. But the duty to examine and to decide, we say, is in general terms. And my Lord Justice Warby raised with my learned friend what the Advocate General had meant by a strict power as opposed to a discretion, and what he appears to have meant, judged from how the Court of Justice decided the case, is indeed a duty, a strict power in Mr. de la Tour's language. That is a duty, because the court's finding was that the supervisory authority had a duty to act to stop the transfer if it reached the view that there would be a breach of the GDPR. And finally, on Article 79 of the GDPR, the right to pursue the data controller, what my learned friend says is, he said, well, why should a complainant have two separate opportunities to have the same complaint resolved? You've got your opportunity in Article 79, why do you need another opportunity before the Commissioner? Well, you need that because that is what the GDPR says in Article 79, without prejudice to any available administrative or non-judicial remedy, including the right to lodge a complaint with the Commissioner, as is confirmed by BE, separate, concurrent, independent remedies. And it's simply not open to the Commissioner to say, in the light of the wording of Article 79, the BE judgment, that simply because he hasn't recouped sufficient money from data controllers, or he hasn't been given sufficient money by the Secretary of State, whatever it is, that there should be only one opportunity for the vast majority of claimants or complainants. There must be two opportunities to have your complaint decided. And those are my suggestions, unless I can assist.
No, thank you.
Thank you very much. Very well. We'll take time to consider your submissions. Thank you very much indeed for the very effective way in which they've been presented. We will, in due course, hand down our judgments, revealing which Mr. Coppell has prevailed on this occasion. And you'll know by now that there is a strong warning at the head of the judgment, which I'm obliged to remind you of in relation to confidentiality until it's handed down in due course, and also that we'll be very grateful for corrections of an editorial nature and an agreed draft order, but not please for further argument, and in this case on no account send us an after hearing note. Thank you all very much.